Greetings once more. Welcome to our series where we've been looking at the Agenda 2030. ZANU-PF came up with a resolution to implement what they call Agenda 2030, whereby they are seeking to extend the term of the current government, which is supposed to end according to the law in August or September 2028, but now they are proposing to extend it to 2030. The title of our discussion today is Premature Litigation Against Agenda 2030 Plays into ZANU-PF Hands. Yes, there are people in the community who have decided that they will want to litigate. They will want to take this matter before the courts for determination. And one of the questions, in fact, several questions have arisen. We are going to look at some of them in this discussion. But once more, let me reiterate the title. It says, Premature Litigation Against Agenda 2030 Plays into ZANU-PF Hands. Now, this is what we want to understand. There is something called advocacy by litigation. This happens by way of, approaching the courts to litigate on a matter of public interest as a way of trying to influence government policy by approaching the courts and asking them for determination on certain policy positions, whether those positions are consistent with the constitution and with the law and so on. So it's called advocacy by litigation. So you are advocating for a political position or a policy position on a certain matter, but you do that by making use of the courts. So the issue of advocacy by litigation has been used extensively, not only in the Zimbabwean context, but in many jurisdictions. So those who are opting to approach the courts, some of them are saying that this Agenda 2030, which is a ZANU-PF Resolution, is a violation of the constitution, and so they want the courts to pass judgment to determine whether this Agenda 2030 is in line with the constitution or not. And then if it is not, then they will ask the courts for some determination, for some verdict. And that's what we want to look at. So we are going to ask ourselves questions around whether in the first place it is a good idea to adopt this advocacy approach. And then if it is, we will also try and understand what could be the possible outcomes. So I have actually got quite a number of questions that I've written down, which I would like us to think about as we progress in this discussion. The first question says, regarding those who want to litigate, because we understand that there's already been an attempt to file a case somewhere in the Bulawayo High Court. So the questions that one has to ask are, what is the cause of action? Because in order for anyone to file a case before the courts to litigate, that is, there must be a cause of action. So for those who are already pursuing this advocacy by litigation, the question is, what is their cause of action? And then, secondly, do they have legal standing in respect of this matter that they seek to bring before the courts? And one might want to ask questions to say, do they have evidence? What kind of evidence are they going to present in order to further their interests, to prove their case? And then what verdict are they praying for? What are they asking the court to do? That's very critical, because at the end of the day, when you are undertaking any form of litigation, whether you are litigating for the purpose of, vindicating your own rights as an individual, or it's this case of advocacy by litigation, the question will always be, what are you praying the court to grant you as relief? What relief are you seeking? And then, so you ask yourself questions: what will a win achieve for the people of Zimbabwe? And what will a lose, again, achieve, whether for the people of Zimbabwe or for a ZANU-PF? Already we have an argument that if this litigation goes ahead and the verdict goes in favor of ZANU-PF, then that would in a way bolster their position, give them the boldness to go ahead and implement this Agenda 2030. But we will look at that in the course of the discussion. So, considering the cause of action as our first question, one wants to say, is there anything that ZANU-PF have done which justifies any filing of a legal case against them? For instance, the resolution that was adopted by ZANU-PF in Mdare is an internal ZANU-PF resolution, really. Any outsider would have no interest in that resolution, at least in terms of the law. You cannot litigate against that resolution if you are not a member of ZANU-PF, because honestly, how are you affected by internal ZANU-PF processes and decisions unless you are also a member of ZANU-PF? So, I hazard to say, from my own assessment of the situation, ZANU-PF have not done anything whatsoever that would warrant litigation against them. Because at the moment they have not done anything in terms of tampering with the constitution. They have not messed up the constitution of Zimbabwe. They have not violated any aspect of that constitution. If they are going to violate it, then that will only happen in the course of time, and like I've said in my other videos, we will know by the end of, by 2028, the end of 2028, if they have violated the constitution. That is, if they do not relinquish power as their mandate comes to an end, then we will begin to ask ourselves the question to say, so now that the term of office will have expired by 2028, on what basis will they then continue to hold power until 2030? So at the moment, one would say there is nothing that ZANU-PF have done which is a cause of action for any litigation by anybody, especially those outside ZANU-PF. So what I seek to highlight here is the fact that if you approach the courts prematurely, they will tell you that you don't have a cause for action, because what the courts will be saying, what is your interest, what are your rights that have been violated, or what are the tenets of the constitution that have been violated? Because until today, that resolution remains an internal ZANU-PF resolution. So there is absolutely no reason why anybody should approach either the High Court or the Constitutional Court for whatever reason, because it has not really, in fact, the law has not yet been violated. We anticipate that it is going to be violated if ZANU-PF go ahead and implement their resolution. But remember, you can't approach the court on the basis of a fear or an apprehension, an expectation. I expect that somebody is going to do this or that. But somebody might say, maybe they will seek a relief in the form of an interdict. But what are you interdicting ZANU-PF from doing at the moment? Because I don't think there is any action on their part which may cause anyone to panic. So as far as the cause of action is concerned, I am of the belief that at the moment the matter remains immature. It is not right for litigation because ZANU-PF have not taken a step other than the resolution that they adopted in their own internal conference. So they're probably waiting for someone to wink, and they're saying who will wink first. So if anybody runs to the courts prematurely, you would have winked first and winked prematurely. And then, as we shall see in the course of our discussion, that may well play into the hands of ZANU-PF and strengthen their hand, and cause them to have that, to develop that resolute position. So at the moment there is no cause of action because they have not mutilated the Constitution, they have not violated the Constitution, they have not even moved into Parliament to table any motion. So if maybe there was a motion, you might say they are threatening. But again, in terms of the principle of separation of powers, there is nothing untoward with any member of Parliament tabling a motion in Parliament for the parliamentarians to discuss, deliberate, debate on, and then vote later on. So during those stages, again, litigation will not be necessary. So I am saying that at the moment there is no cause of action. I don't know what papers, what cause of action they will have disclosed these litigants would have disclosed in their founding papers. But to be honest, at the moment there's absolutely nothing that ZANU-PF are guilty of, other than having made their own internal decision in their own internal organization, which has nothing to do with anybody who's an outsider. So that must really be taken into account. So anybody who decides to bring legal action against ZANU-PF on the basis of Agenda 2030 will have to demonstrate what their cause of action is. What is the wrong that ZANU-PF have done? And at the moment, I am not seeking to defend ZANU-PF, but let me simply say there is absolutely no ground to hold them accountable on anything, because they just expressed their own wishes in terms of their own resolution in their own internal organization, which has got nothing to do with anybody. Hence, I repeat that a premature litigation against this Agenda 2030 is like playing into the hands of ZANU-PF, like strengthening their hand. It's like giving them an arsenal, because then you are allowing the courts to test the matter before ZANU-PF really bring it even to the Parliament. And if, for instance, the courts dismiss the matter, then ZANU-PF will have the reason to go ahead and say, yeah, our actions are legitimate. There's no one, in fact, the courts have okayed, they've given the green light for us to go on. So those are some of the things to think about. So, the question of what the cause of action is comes in tandem with who has a standing. Well, one might say, as a Zimbabwean, anybody has standing, has local standing, has the right to stand in defense of the Constitution. But again, you can't claim to defend a Constitution when nobody has yet done anything that threatens the Constitution. Because somebody might say, the court might say, what if ZANU-PF do not eventually bring, rather initiate those amendments that they've spoken about, constitutional amendments that they are proposing? Because the court is not a legal advisor. The court does not, you can't bring to the court a matter that is just academic in nature, where there is no pending in fact there's no cause of action, there are no rights that are being violated, and you just want the court to make a pronouncement in advance, because courts deal with real matters, they deal with concrete matters. So until the matter really crystallizes, until the ZANU-PF decision crystallizes into some real action, and we begin to see steps in Parliament and maybe even beyond Parliament trying to implement this Agenda 2030, then you will have a cause for action. So at the moment, you can't have a right to stand or locus standi unless and until there is a violation of rights, or some rights are threatened, or you have a reasonable belief that rights are about to be threatened. So at the moment, as I said, only people within ZANU-PF have locus standi. They have the right to approach the courts if they have any grievances against this resolution. But as for outsiders, there is absolutely nothing to hastily approach the courts on. So the time will come. I'm not saying that the time will not come. It will come. But you see, acting prematurely is as foolish as not acting, or sometimes even more foolish than not acting. So it would be in the interest of the people of Zimbabwe, not for not anyone to rush before the matter matures and try to, get it decided by the courts, because then, as I have already said, that would just be of an academic nature, and courts do not discuss, they do not review matters that are of academic interest. They only deal with concrete facts. Why? I have already said, courts are not legal advisors. They don't advise legally, they decide on matters that have taken place. So at the moment, so the issue of standing, no one has standing as long as there is no cause for action. And then as for the issue of the evidence, if there has not been any, if the cause of action has not matured, as it is, those approaching the courts will only be approaching them on the basis of an expectation, a fear, an apprehension, and therefore you can't have evidence other than saying ZANU-PF met and made and passed a resolution. And the question will always be, so how are you affected by a ZANU-PF resolution? And as I have already said, only those from within ZANU-PF who will have grievances about that resolution would take it before the courts, and they would have the right to stand and litigate on it. But as for the ordinary Zimbabwean who is not a member of ZANU-PF, you have no reason whatsoever to start litigating on that. So that then brings us to the issue of the relief that the applicants would seek before the court. Because from what we have heard, the applicants, according to that case that's still subject to speculation, the respondents are ZANU-PF as first respondent, then the Minister of Justice, Legal and Parliamentary Affairs, the Speaker of Parliament, then the Attorney General and the President of Zimbabwe. So the question then would be, on what grounds does one, for instance, seek relief against any of these people? If you are not a ZANU-PF member, what grounds do you have to be litigating against ZANU? What is it that ZANU have done outside of their own organization which warrants, maybe an outcry from outsiders? Because it's just a statement, which is just a political statement. So would you then be expecting the courts to make decisions and pass judgments on political statements? Is there any wisdom in that? because ZANU-PF are a political organization, and whatever resolutions and political statements they make, those are not subject to, you know, determination by courts unless they are in outright violation of rights. But at the moment, what rights have they violated? I can't imagine any. And then the Minister of Justice, what wrong has the minister done so far in terms of you know, evidence that you may bring before the courts and say this is what the minister has done? Because there has not been a step in Parliament. So it matters here when, if at all, this litigation is going to take place. Certainly it can't take place before anybody has done anything that violates the law. So the Minister of Justice so far hasn't done anything. The Speaker of Parliament, again, there's no motion that has been brought before the Speaker of Parliament. So if you are going to litigate against him and ask him to answer questions, what questions? Because as long as there is nothing tabled before him, then he has no questions to answer. And besides, in terms of the principle of separation of powers, the court cannot order or instruct the Parliament, because the Parliament has its own autonomy. It has got its own procedures and mechanisms for operation. But of course the court may then look at the outcome of a parliamentary process and make a pronouncement after it has been completed. But to ask the court to stop the Parliament from exercising its powers and duties of legislating as well as amending the constitution and so on, that would then violate the very principle of separation of powers, because then you would be expecting the court to instruct the Parliament and also to instruct the executive, that is the president. That on its own is very problematic, because as I have already said, it violates the principle of separation of powers. Basically, therefore, it matters that in litigation, you should be careful who you cite as a respondent and whether you have got the rights and the powers. Because as you can see, surely, if you bring in if you take the Parliament to court to bar the Parliament from amending the law, trying to amend the law, then you are trying to clip the wings of Parliament using the court. And on what basis and on what principle will the court be able to make a pronouncement and tell Parliament not to move ahead with certain you know, processes and procedures that it wants to adopt? Because at the end of the day, the court cannot predetermine what Parliament can do and must do. But if, for instance, these amendment processes are allowed to run right through to the end, and somebody is aggrieved by the way the processes have been conducted and so on, then and only then can you take the matter to the courts for determination. But as of now, whilst the Parliament is still trying to exercise its own legislative functions, you can't then bring that matter before the courts and ask the courts to stop and interdict the Parliament, to order and instruct the Parliament to stop its processes. In terms of the principles of separation of powers, the court will not grant you any relief of this kind. And the same applies to the Attorney General. What is it that the Attorney General has done so far to warrant any intervention from the courts? And the President of Zimbabwe, what is it that he has done? Because until he has done something, you can't move and litigate against him. It is a matter of principle. So, as I am saying, somebody here might want to jump the gun. And like what others have been speculating, such litigation might even emanate from ZANU-PF, sponsoring a litigant outside who may seemingly not be a member of them, so that at the end of the day, the interests of ZANU-PF are advanced by way of taking the matter before the courts and having the courts determine that there is nothing wrong. So as a way of giving ZANU-PF the green light, that's the only benefit that they might get. So activists, political activists outside of ZANU-PF are advised to stay away from the courts, especially at this moment when nothing has been done by ZANU-PF. Because after the resolution, there's been so much hype and so much talk, but until the matter is tabled before Parliament and then processes for the amendment of the Constitution begin and so on and so forth, then can we only begin to maybe think about taking the matter to the court, the High Court or the Constitutional Court or whichever is the relevant forum for that matter. So at the moment, if you are going to be litigating against the president and asking for relief, what relief are you seeking against the president? What is it that he has done in terms of this Agenda 2030? Because as I have said elsewhere in one of my other discussion videos, by September 2028, if the president has not called another round of elections to replace this current term, because this current term of government, whether you're talking about Parliament or the executive, is going to end in August or at least in September 2028. So if the president does not call the election for 2028 period as expected against according to the Constitution, section 143(1), then you will be in a position to litigate against him at that point. But at the moment, we are still in 2025. So there's nothing that the president has already done which may justify litigation against him. So if you take this matter as it is, the courts will simply dismiss it and say there's nothing that the president has done. And truly, they will be telling the truth. Because at the moment, there's nothing wrong that the president has done. At least in terms of this Agenda 2030, he has not done anything. So, hence I'm saying in terms of the verdict being sought, in terms of the relief being sought, you can't seek relief when you have no cause of action. You can't seek relief when none of your rights have been violated. And as I said, somebody might want to act by way of an interdict. But what will you be able to interdict? Do you have enough facts for a court to even decide to interdict anybody from anything? Because the court certainly cannot interdict Parliament from amending the Constitution. Because Section 117 says, in subsection 2 says, one of the duties of the Parliament is to amend the Constitution according to Section 328. So it's already a protected right and a protected duty of Parliament according to Section 117. So if you are going to then try to get the court to interdict, to stop the Parliament from, amending the Constitution, then you are asking the court to take away from the Parliament its rights and its duties, and that would be in violation of the separation of powers, as I have already said. So what then would be the kind of relief that one is seeking? So you should be very careful not to play into the hands of ZANU-PF by rushing prematurely and bringing action before the courts when the right time has not come, when the matter has not matured. Because at the end of the day, as long as the matter is not mature, the courts will dismiss it and throw it away. And so that brings us then to the next question, to say, what will one achieve if for instance the courts were to rule that there is anything illegal in terms of ZANU-PF resolution for 2020, the one adopted in 2025 concerning Agenda 2030, if the courts, I don't know, as for relief, as I have already said, the relief being sought itself is quite questionable. Then if the courts could say that that resolution is illegal and unlawful, then it would mean that ZANU-PF have to stop it. But as I have already said, there are very limited grounds upon which the court can find that the resolution is unlawful, because it is an internal ZANU-PF resolution, and they have not even proposed to use unconstitutional means to achieve it. They said they are going to go into parliament and they are going to use their numbers and they are going to lobby the members of parliament, the legislators, to adopt the resolutions, rather to adopt some amendments to the constitution that will then make the implementation of their resolution possible. So they have not proposed any unconstitutional means of achieving that, and so you can't really expect that the court will stop them by any means. But the big question is, what will a lose mean? For instance, if these litigants go ahead with this suit and then they litigate the matter, it comes before the courts, and then the courts eventually find that there is nothing wrong. At the moment, because that's what the courts will find, there is nothing wrong with the ZANU-PF resolution, then it would enable ZANU-PF to proceed with the process. And you see, as I have already said, it should be a step-by-step observation of ZANU-PF steps, so that litigation can come at the right time. At the moment, if it comes prematurely, it will exonerate ZANU-PF and create an impression that they have not done anything wrong. So as it is, a litigation that happens in 2025, 2026 will have a different outcome from a litigation that happens in September or October 2028. Because as I have already said, by September 2028, the term of government will have come to an end. So the executive, that is the president and his deputies, must have vacated the office, and a new president must have been elected. And the parliament, all those parliamentarians must have vacated the office by September 2028. And the new legislators, whether for the General Assembly or for what you call the National Assembly or the Senate, some new legislators must have come in to take their place based on a new mandate, on the basis of a new election that, according to the Constitution, is supposed to be held sometime in August 2020, August 2028. So I'm saying, if you litigate now, the cause of action does not exist. So you will lose, and you will then exonerate ZANU-PF and create an impression that they have not done anything wrong. But if you wait until the expiry of their term in 2028, and then you see them proceed now claiming to have a right to govern until 2030, then you will have a reason to approach the court and say, but these people have overstayed their term of office, because it is 5 years, now they are sitting for 6, 7 years. So by that time, your case will be mature, the matter will be mature, it will be ripe. So even the courts will then have substance to deal with. But at the moment, courts don't have any substance to deal with. So so what then needs to happen, I think the public must be aware and enlightened of the fact that it is not enough just to have people rushing for litigation and so on. Litigation is fine when it is done at the right time. If it is done prematurely, it will give an advantage to ZANU-PF. It will legitimize the resolution, because then the courts will make a declaration that there's nothing in principle wrong with the resolution, which is effect at the moment. And so it will make it difficult to then challenge and bring the matter up again on in 2028 or 2029, because ZANU-PF are likely to argue that this matter has been dealt with before. You know, on technicalities, they will say that they have already stood in jeopardy on the grounds of the litigation that is being proposed now. So in terms of the double jeopardy principle, or what one might call the res judicata principle, they will resist, they will defend themselves by way of saying the matter was brought before the courts in 2025 and the courts dismissed it, so no one has a right to bring the matter up again in 2028. And by that time, 2028 or 2029, the matter will have ripened. All the, you know, the wrongs likely to be done in terms of this resolution will have been done. So why not wait until everything comes up, then you can deal with it on the basis of that. There is a Ndebele proverb which says, "Inhlwa kayibanjwa ngekhanda." So you don't grab that insect while it is trying to come out of the hole. You know, there are those flying insects which you sometimes eat. And the proverb says, wait for it, that insect, wait for the insect to come out of the hole and begin to crawl, then you can grab it. Because the moment you try to hold it by its head, it always has a way of going back into the hole. So inhlwa ayibanjwa ngekhanda. Let's not be hasty. No one should be hasty. Don't be in a rush. ZANU-PF are not in a rush. They are talking about 2030. So wait for them. When they get to 2028 and you see that they are not vacating the office, then you can take the matter to the court. But of course, in the meantime, you should be monitoring what they are doing. You should be bringing pressure to bear upon them. You should be enlightening the public about what needs to happen. And maybe as a last statement, as a parting statement, please be wary and be careful of people who pretend to represent the public when they are pushing a ZANU-PF agenda. Because as I have already said, some of these litigants or some of these, you know, these processes of litigation will originate in ZANU-PF, but they are most likely to be fronted and be presented by people who are known as maybe opposed to ZANU-PF. And then at the end of the day, people will think as usual that ZANU-PF are not involved, but it might just be their way of sanitizing the mess by bringing in somebody to litigate on their behalf, a hired litigant kind of, who is sympathetic to ZANU-PF, but on the face value gives and presents an impression that he or she is not sympathetic to ZANU-PF. So be very careful of who you follow, especially on this matter. And it may be difficult to prevent them, but let the people be aware that such litigations will not work in favor of the people. Thank you very much again for being part of today's discussion. I hope it has enlightened you on this and that. I have said quite a lot of things. If you have any questions, queries, or any other remarks to make, difference in opinion, please feel free to contact me so that we can talk about these things. In the meantime, thank you very much. May God bless you. Bye-bye.